taking older homes, making them nicer, and people are staying here. And those tax dollars, everything's staying here, so I think that's all a wonderful thing. And then I obviously built the little side thing, and when the inspector said it can't go out quite that far, it was we changed it, and then I think I put it some in the notes or whatever, but basically, when going through the inspection process, and going through each item by item by item, and you can't have that, you can't do that, you gotta change that, and do this, and change that, and I was like, wow, I mean, like, how do you even build a house? I was shocked at how hard it was to pass everything. And so on one item, we were inside, and I have some back steps that go up to a master bedroom. So at the top of the back steps, it goes right into the master bedroom. Well, it's got a weird roof line, so when you open the door, you can't open it this way because of the roof line. So it does open out towards the steps. So at that time, he said, you can't have that door there. And I was like, what do you mean I can't have a door to my master bedroom? And he's like, no, because somebody could, open the door, obviously, and fall backwards on the steps. And I was like, are you kidding me? And it seemed like that for everything, every little thing. And so on that one, I was told at the time you have to do this to pass. And now after you pass, that's up to you if you want to put a door there. And so I didn't ask, is that limited to what you can see and what you can't see? I didn't ask, is that inside or outside? I just took them we have to do all these things to pass. And so obviously now all this is happening, but I've gotten permission from all my neighbors. All my neighbors love it. Everybody's loved it. Nobody's complained to my knowledge. And I've got my attorney, Ellie Hill. So she's going to explain some of the other reasons and everything like that, because I don't think you want to hear from me anyway.
How far is your side of your house from the property line?
It is about 15 feet, I believe, almost right at.
So even the smaller awnings.
That was 6 feet. That was 6.
That one's 6 right there?
Yep. And then the little piece of wood out in front of it makes it go an additional, I think it gets to about 13-ish. And so it's off the property line about 3 feet.
And that is a structure, right? Those are in those.
Yes, those are, yes. And when I did this, by the way, I said, why is this? Why is this rule in place? And was told it's a fire hazard. Like if that caught on fire, it could spark the neighbor's house. And I was like, oh yeah, well, I guess so. But there's a wooden fence, trees, that little trellis thing that sticks up there, that was allowed to stay. And the only thing added was metal roof. So I'm like, well, metal doesn't usually catch on fire.
Well, I'll tell you, part of our issue is the Planning Commission writes these regulations.
Yes.
And town council approves them. So that's why it's 15 feet for us. One of the big things you need for a variance is a hardship. Do you have any kind of hardship?
I'm gonna let Ellie.
All right.
I'm going to present on some of those issues. I want to point out that we've been talking about.
Could you introduce yourself, please?
Yes, sorry. My name is Ellie Hill. I'm an attorney with Patrick Beard.
Okay.
And I'm here on behalf of Mr. Foreman. One of the things I want to point out, and I spoke with the inspector about this prior to the meeting, is if you'll look at the notice of violation, the actual side setback is not 15 feet. This is a small lot. And it's a provision in the zoning ordinances for setbacks for small lots of record in section 817 on page 81 of the ordinance. And it provides that if a lot of record is smaller than the current minimum lot size in the district, which is 1 acre, the ratio of the lot size in square feet to the minimum lot size in square feet shall be determined.
Actually, it's a half acre.
Okay, well,
So
half acre.
what size is the lot?
Do you?
I don't know the size of the lot, but I can tell you that in the notice of violation, it is referenced that the side setback is 9.3
Yeah,
feet.
yeah.
So we talked about before, if you want to, there we go. Yeah, the 9.3 feet there. And Chuck, if you don't mind, you'll put it back on the picture of the home, please. There you go. The patio itself, for reference, is 13 by 13 feet. The property line's another 3 feet off of the patio. So the home itself is actually 16 feet off of we measured that this afternoon. It's actually 16 feet off of the property line. And so when you're talking about a 9.3 foot setback, we've got about 6 feet of room there. And I believe that what is shown in the picture is approximately a 6 foot awning. So that would not be in the
Setback.
setback. What we are requesting today is for, if you'll scroll down, actually it must be up, yeah, is for that roof to be allowed to extend, which is, again, 3 feet off of the property line to the edge of the roof.
I got a question at this point. The other pictures you showed above, those are previous pictures. These are the actual present-day pictures.
That's correct. And as Mr. Foreman mentioned, and this is one of the hardship issues that we have, is when the final inspection occurred and Mr. Martin came out to the property, the representation was, once, I don't care what you do after it passes the final inspection. It was made with regards to a door, as Mr. Foreman just mentioned to you, somewhere in the home. But Mr. Foreman understood that to mean that after the inspection passed, that he could in fact put this roof back on. And so he spent time and money in having the roof put up, taken down, put back up, and now would potentially incur a significant cost, about $4,000 to take this down.
It's really too bad that that happened, but that's not really our problem. If somebody tells you that you can't do something and it's not legal, I would think that would be enough to tell you it's not legal. So just because he wanted to go back and put it back, Chuck has already told him once, that's not legal.
And told me that I could do
And we are sorry that you figured that you could trick the system somehow or the other. But
So that's why we're here, sir, is to get a variance. And I think that the board needs to consider the input of the neighborhood. And one of the things that's referenced here is the literal interpretation of the provisions of these regulations would deprive the applicant of rights commonly enjoyed by other properties in the same district under terms of these regulations. Mr. Foreman has taken the time to drive around and point out where there are other homes that also have areas where there is a side setback violation. And those homes, are existing. Those violations are existing today. We also found out that Hamilton County zone, and I know this is a Hamilton County.
Can I interrupt
town of
you?
Single Mountain, but Hamilton County.
Can I
zone-
interrupt you? We have our own zoning regs, so Hamilton
Sure, we
County
understand that.
doesn't apply.
But Hamilton County would allow this structure. It just has to be opened on 3 sides. Another thing I want to point out is Mr. Foreman has spoken with his neighbors. There are not any neighbors here in opposition that we're aware of. We've obtained signatures from owners at 210 North Palisades, Ann and Ernie York, who are okay with this structure. Dee Carnes, who's the neighbor immediately to the left in the picture there. Tom Blewett and Marlene Blewett at 205 North Palisades. And James Ekis and Judy Ekis at 206, who have all said that they're in favor of Mr. Foreman being able to have this structure on his home. And I certainly understand that there are situations in which the ordinances need to be strictly complied with. But there are also provisions in your code for a variance, and there's a reason for that. When an applicant, such as Mr. Foreman, has obtained the approval of his neighbors, he's been told that the main...
Ma'am, if you're going to say something, it needs to be relevant. Is there anything in my book that says we check with the neighbors?
The problem is the variance goes with the land and the property. Your neighbors could move in 2 years or 6
Exactly.
months, but this variance will last forever. So
We
you may-
need a hardship.
That's why the
We don't
neighbors-
see the hardship.
Well, the hardship is the reliance upon the representations of the inspector. The fact that there are other violations occurring all around Mr. Foreman.
And Mr. Foreman is welcome to file a complaint against all of those people whose houses you took pictures of. And as a real estate agent, that wouldn't be good PR, I wouldn't think. But that doesn't make this right. Two wrongs don't make a right.
I wasn't trying to trick the system, by no means. I was told, you have to do these things to pass your inspection, and we don't care what you do. When I'm told that, I didn't say, what if you can't see it, or can you see it? So I wasn't trying to trick you. I legitimately, honestly thought, oh, okay, then I can do this. I wasn't, by no means. And I understand you have rules and rules and rules, but to me, the definition of variance is something outside the rules, and you think outside the box. If we're just gonna go by the rules, there's no need for a committee, and there's no need for anything. You just, that's the rules.
That's right.
I mean, that's what I'm saying, so that's what I'm trying to ask.
When we were found out about the violation, applied for the variance, that's why we're here.
And when our inspectors may not have said that, doesn't mean you can like build a turret on your house or put a pool in the front yard. My issue is that you were aware that after he told you to take it down, it's kind of gutsy to put it back up, wouldn't you think?
No, again, he said, after you pass, we don't care what you do. It has nothing to do with me
Okay.
trying to trick or show up or.
I don't think that of you. I think we need to move
Well,
from
can I
where we
have a
are
question?
now.
I've got one question I would like to ask. How are we back in this situation? If you were asked to remove or just before you had to tweak everything, so how did you end up learning you needed to come and make a variance request?
There was a notice of violation issued by the town.
Okay,
And when it first came up, the first time, I was told, that I was wasting my time to come talk to you guys. That's what I was told by Chuck. I said, I can spend my $75 and I can ask for my roof and go about it in the front end, but that I would be told no. And I thought, that's fine. Why would there be a committee? Why would there be a variance if it's gonna be a no? He said, that's what it is, and he was nice enough to work with me and try to get the.
Can we move
16
past
on.
Chuck's business? I mean, can we move past what Chuck
Yeah, I
said?
was going to tell you, there is a forum if you think the building inspector's made an error, and that's to request an administrative hearing. The variance is not the answer. But I think we've heard most of your arguments. We've read them.
If I may, if the board is inclined to deny the request for a variance, I would ask that it be tabled to allow us to talk about what other options are available to Mr. Foreman. He's already taken it down once. I don't want to see him put up the 6-foot awning that was there initially, only to have another notice of variance issued. I'd like for us to be able to work together and come up with a solution for everyone.
You said the awning's within the setback. Correct. It's not in the setback, right? It's the shorter, the small awning is legal.
If
I
he's a
would
small-
suggest
And
that,
that goes down to 9.3, right? That-
Yeah,
or
if he's-
Is that correct, Chuck?
9.3 is the setback because of small lot of record. But because it is a small lot of record, and after you do the math and the ratio, and it ends up being a 9-foot setback, what's his true setback? Like, how far can that awning come out off of his house?
It's a 9.
You said it was 16 feet.
It's my understanding that that's the 6 feet, but again, I think that Mr. Martin and I talked about that this morning. I'd like to have an opportunity.
I think if you read 1104-010101, it tells why you can give a variance. You will see that you do not fall in that category.
We respectfully disagree. We believe that we've presented proof that special conditions and circumstances exist, which is 1104-010101, that the literal interpretation would deprive him of rights commonly enjoyed by others. We addressed that special conditions and circumstances do not result from the actions of the applicant. That's not the case here. And that granting the variance requested will not confer on the applicant any special privilege that is denied by these regulations to other land, structures, or buildings in the same district. We have reviewed those.
It seems pretty plain to me.
All right,
Well,
thank you.
out of curiosity, because like I said, that was in 20 minutes, I found those 5 or 6 houses in violation. So,
Can I read you part of the rules?
oh, no, I wasn't.
It's 1104-0102 says, no non-conforming use of neighboring lands or structures or buildings
Correct.
give you the right to a variance, basically.
Yes, I understand completely.
Okay.
What I'm saying is this, I'm asking 2 questions.
Yeah.
One is, obviously, there are one rule saying that I also can't be denied something other people have. And then.
Well, it doesn't say that. I just read you that it doesn't say that.
What was it say?
1104010102 states that literal interpretation of the provisions of these regulations would deprive the applicant of rights commonly enjoyed by other properties in the same district under terms of these regulations.
What's the square footage of your home?
Is now 3,800 square feet.
So you're enjoying 3,800 square feet of privilege on your lot, right? I mean, you're saying this
He is
one
paid
little
for-
overhang's denying you the right to use your property? The absence of this little porch is denying you the right to use your property, is that what you're saying?
I built that was a wall. Now it's a door and it's a sidewalk and it's got brick and steps that I've wanted for 10 years while I've lived here.
We aren't-
So absolutely it's denying me.
We aren't in your house.
No,
We have never looked in your
I'm just
house.
answering the question.
Let's move on.
So, and then
We'd
my other
like-
question was.
Okay, go ahead, I'm
So
sorry.
if somebody reports something, does that have to come through? Like, in other words, if all these other violations, if somebody sends a letter in and says, hey, they're in violation, do they have to come through this as well?
Well, the building inspector researched it. Some of these probably predate our zoning regs, which makes them grandfathered in. Some may have variances, you know, each case would have to be looked at. So
There's a lot.
we'd like to hear from our representative from the Southeast Tennessee Development District. He also gives us an opinion on the case. If we could- Thank you.
Thank you.
Thank you.
And we do like your house, by the way.
Yes,
It's
way to
very
go.
So you have a new review from me. It should have been placed in front of you before this meeting. Again, just to review, the applicant's requesting to build a patio on the side of his house. Covered pretty much what they're wanting to do with this. So my first request for the Board of Zoning Appeals to interpret the definition of a structure. That's laid out in the analysis in the first paragraph or so. The definition of a structure states that anything constructed or erected with a fixed location on the ground or attached to something having a fixed location on the ground. Among other things, structures include buildings, mobile homes, walls, fences, billboards, and poster panels. The important language here is that among other things, structures including buildings, walls, going on, so on. The emphasis on among other things. Again, I cannot speak for Chuck, but I believe this is the language that you used to necessitate this request for a variance. Is that correct, Chuck? The definition for a structure necessitating the need for a side setback, being that the structure includes the overhang into the setback. Is that correct? So, in my opinion, it's up to the Board of Zoning Appeals to interpret this language and make a determination to necessitate his correct action. If it is found that the porch or patio is in fact part of the structure per this definition or otherwise found in the zoning ordinance, then a side setback is required. And I move on to section 1104.1.01. Item number 1, I believe that there are no special conditions or circumstances that would permit this. Number 2, while literal interpretation of these provisions may deprive the applicant of rights commonly enjoyed by other properties in the same district, as shown by the applicant's attached photos and examples, and while the BZA has previously approved similar requests, this section prohibits non-conforming uses and therefore previously approved variances from being considered grounds for approval. Again, item number 3, these special conditions or circumstances do not exist. And item number 4, granting this variance would give the applicant a special privilege that is denied by these regulations to other lands, structures, or buildings in the same district. Given that the applicant has not shown any extraordinary or exceptional situation or condition that would result in undue hardship upon the owner, nor meeting any of the 4 criteria set forth in section 1104.01.01, staff finds that there's no basis for a variance.
Okay, any questions for Garrett? Is there anyone else here who has pro or con on this project? No. Any other questions? You guys ready for a motion? So we don't have any-
Can I ask, I do have a question.
Sure, go.
They want a delay so that they can, consider options. What options are there? I mean,
If I had, I've talked to Mr. Foreman about this. Of course, one of the options would be to decrease the request for the setback away from the property line. Another option, and I don't believe we would need approval for this, would be to have a trellis, a trellis roof area. And it would,
You would
we would
need-
like for that to be, as I understand it, a trellis is not considered a structure. It's an exception. It's a,
We had someone move a trellis a few years ago because it was too close to the property line, and a big stone fireplace.
okay.
I have a question for you. I mean, I want you guys to be able to enjoy your home. What's the purpose of the roof? Is it just shade?
It's a covered grill area, so of course if it's storming outside, the patio is right off of the kitchen, allows Mr. Foreman the ability to go out on the
Well, I have a question for Chuck. Is there any way we could have, as long as it's not attached to the ground, is there's any way to have a type of gazebo we could just place there? And that would not be an attached structure. It's not attached to anything, right? I mean, I don't know if that would go with your house or not,
Situation like the,
as long as it's movable, is that possible?
there was a slab there,
Right,
the people were made to move it before I came here.
the slab?
The ridge rock. There was a slab there.
Okay,
Then when somebody else moved in, they went and put some structure back on the slab, which, like I said, the slab was not removed, but the structure was. And so that was when we had the case with the ridge rock, that it was too close to the property and had to be removed.
that was all in the ground though, right?
Well, I mean, the slab was not an issue.
Right.
They thought because the slab was there, that they could just put the structure.
Right.
I'm more than happy to come back next month with 4 or 5 different options that obviously is gonna cost me money, but if I could have my functionality of my grill area and where I put a door and stoop and steps and make it functional, and I'd be more than happy to present 3 or 4 or 5 options, and then if none of those get approved, then I guess I've.
Options within the setback, I guess, John.
What's that?
Options within the setback.
I guess, yeah, just whatever, yeah.
So I have a question. Can you all hear me okay with my mask on?
It's a little difficult.
Okay. Did you put the door there?
Yes.
Okay, and then were you notified, was there anyone take notice of the door and ask what its purpose was prior to building anything?
The building plans were approved and there was a building permit obtained for the construction.
Right, but the door was there, and then you'd always intended to put a porch there. And that porch was in the plan? On the original plans that? Okay.
Everything's verbal, so it's like, everything's like the builder and the inspectors and everything's like.
But you had a building plan?
Yes.
And
Yes, absolutely.
was the porch on the building plan?
I think so. I mean, there's so much changes to your process.
Okay.
So many of the problems we run into are parcels that are less than half acre,
They're what?
less than half acre.
Oh,
This is common, and to run into problems like this doesn't change anything. But I'm saying that's where the yeah.
As far as the delay goes, it just is whether you qualify for a variance or not today. So we'll probably decide that today. But you can reapply in 12 months if you're turned down, which I don't know if you will be.
Yeah, and if the town's inclined, I mean, if it seems as though you're inclined to decline it, I would ask that this just be tabled for a month to give us an opportunity to speak with Mr. Martin and see if we can come to a reasonable modification of our request for the variance.
Chuck, how long have y'all been talking about this? This has been since December, right?
The notice of violation, I believe, came in.
This has been since December, the structure's been up there, right?
I think you have a right to withdraw your application at any time before a decision is made. Would you agree with me? So,
Can they do that?
well, there's our town attorney. They can withdraw it up to any time a decision's made, I would think.
And as I understand it, if we allow the vote, we can't bring another request for a year, for 12 months.
If it's for the same reasons.
so you'd have to take it down and then wait a year to come back. And then what about?
Withdrawing the request.
What about the month delay? Is that's just kicking the can down the road, isn't it?
Probably, but if they withdraw it, they withdraw it.
It's been 6 months they've been working on this.
Yeah, I mean, this is going on. This needs to be.
Yeah.
Okay.
I think we're going to withdraw our request at this time.
Let me ask the town attorney one thing. If they withdraw their request, they still have to comply with the order from the building inspector?
Ask again, I couldn't
Oh,
hear him.
sorry about that. Do they still have to comply with the building inspector's order to remove the structure?
Sure.
So how does that work?
Well, we could, but we are also able to submit another variance next month.
Yeah, you could, I guess.
I think we'd like to pursue that path.
Okay,
Thank you.
thank you.
I thought you said it couldn't be for a year.
And if we vote on it.
Oh.
Okay, so let's, I guess, probably see you guys next month. If I can find my agenda, the next agenda item was 405 Georgia. And we thought we were going to have an administrative hearing, and this morning Chuck told me that he hadn't scheduled an administrative hearing. We also didn't get any records of the property until this morning. So I think we should postpone any discussion about this parcel, and I'd like to schedule an administrative hearing as soon as possible, probably 7 days, something like that, if we can get a room. Is anyone?
Is Joe Kellen here tonight?
I told her she didn't have to come because we weren't going to have a hearing.
Okay.
You want to ask the town attorney how soon we can schedule it?
State law says 7 days, although the town normally has 14 for a BZA meeting, but we've already given two weeks' notice for this hearing. Is there a problem if we try to hear it as soon as possible?
Well, I think 2 weeks is better, particularly with the holiday,
That's true.
on Monday, just to be safe.
Okay. Yeah, we thought we were going to be able to hear it tonight, but I'm worried about issues of public notice, and it wasn't really stipulated clearly on the agenda what we were going to hear tonight.
Well, I did notice, my name is Steve Jakeway. I am representing Ms. Hartman here today. I'm her counsel. And before I say anything, I do appreciate y'all's service. I've been a resident up here for 34 years and been on boards, and I know everybody makes great salaries being on these boards. So thank you for your volunteer time. It's what makes the town Signal Mountain. I did notice that it was not assigned a number, which sort of told me that it was here a little bit out of the ordinary. Do I understand you to say that we would pass it for 2 weeks to be scheduled, and it would, what I did not understand is we have not requested and don't have a motion before this board for a variance. I know it's pursuant to Ms.
I will
Kelly's.
read you the section from our rule book here. Appeals, hearings, and notices, section 1003.
No, I don't oppose the passing of 2 weeks. I just didn't know exactly, when we pass it for 2 weeks, what will occur in 2 weeks.
I was about to tell you.
Okay, very good, I'm
All
sorry.
right, so basically it says, interpretation or administration of these regulations may be taken by any person aggrieved by any officer, department, board, bureau of the town affected by any decision of the building inspector.
Right,
So such appeal shall be taken within a reasonable time as provided by the rules of the board, with the building inspector and with the Board of Zoning Appeals, a notice of appeal specifying the grounds. And she sent us all emails on April 23rd specifying that she thought the outbuilding was illegal and didn't have the proper inspections.
And she also at that time requested a formal hearing on this from our town council, a town manager
She followed
in writing.
protocol, yes.
So it has been asked for.
and I'm not objecting to that, I'm just asking for clarification. It seemed to me that there were really two issues in her letter. One was the particular, she was objecting to the nature of the improvements to the property. And then secondly, she was objecting to, she alleged that it was in violation of setback requirements. As I understand it, the building inspector has approved all the modifications. I did not understand that there had been any decision or ruling by the building inspector with regards to the alleged violation of the setback requirements. That's what I was asking for clarification for, because I didn't, now, I understand she's objecting to it, but I think the rules say, or just for clarification, it seems that it's basically, the board's position is to deal with a decision or refusal made by a building official or other administrative official. And I didn't know there had been ruling as to the setback issue. That's the only reason I was asking for
Let
clarification.
me read something. This is from that lady. I feel like I am a target on my back, is looking like a troublemaker for the citizens. And she is a bad person trying to contact the building inspector, town marshal, the town manager, fire chief, stormwater, town council, and the attorney. With all this, she got no replies. Where was she supposed to go, Chuck? This lady has appealed to the town manager, she's appealed to the mayor, she's appealed to Chuck. If there's nothing written down that she's complaining, somebody has to listen.
I do think that her letter was a bit cloudy, though, in terms of the actual decision or refusal of which she was seeking an administrative hearing. And I do think that we need to be precise in our request of what decision she is appealing and would like an administrative hearing based on.
I think our citizens deserve to have a fair hearing and not be shuffled around. This has been going on since the first of the year.
With all due respect, I've lived up here 34 years. I've dealt with it. She absolutely deserves to be heard. No question. I'm asking for a clarification because as
We'll
I
get you that by tomorrow.
And that's what I'm just
How does that
asking.
sound?
I'm not.
Well, we have
objecting.
asked our town building inspector, our town manager, and for exactly those for several months, and we have gotten nothing.
Well, I think they just made, I don't think a decision has been made with regard to setback. The approval of the improvements was just recently made. The letter that was initially sent was in December before any final decision was made. But be that as it may, I'm not objecting to her being heard, and I appreciate the board hearing. I'm just asking for clarification because, again, we're not asking for a variance. She is objecting. I've got that. It's a right under the rules and regs. Absolutely. I just want
But
clarification.
everybody she contacts doesn't seem to hear. So nothing ever happens.
I'm not disagreeing with what you're saying. I'm just asking for a clarification.
Can I interject something? Is there a procedure or a form which she could fill out with the town that just simplifies what her request is? I think that would be very helpful for me as a BZA member as well, to have a process or a procedure to know what her exact request is.
Well, one of her complaints was the house was totally renovated without any permits. So
I
that's-
totally
that's being
understand that,
remedied.
but
Actually, this is her complaint right here.
Do you want to read it?
I think there were many things in that complaint, though, that do not
what
come
I'm
under the purview of the BZA. And I think so it just needs to be clarified.
Right, and we'll only hear what's pertinent, I think, but I'll read the administrative review paragraph here. We're to hear and decide appeals where it is alleged by the appellant there's an error in any order, requirement, permit, decision, or refusal made by the building inspector or any other administrative official in carrying out the enforcement of these regulations. So we'll get her to clarify exactly what it is tomorrow, although I think it's pretty clear in that some of her complaints, but we'll contact her and touch base with you tomorrow. If you'll leave us your card.
I will.
You're Bob, right? Bob? Is that your name?
Steve Jakeway.
Steve, I'm so sorry.
You were close. That's
Yeah. Essentially, I think we're taking the role of the building inspector during this
Yeah.
hearing.
And that's fine. I mean, if that's what it is, I just
think
want
Harry
to,
wants
for
to
purposes of preparing for it,
Yeah.
just be able to.
Sure.
Clarification, but no, I assume it would be on a Thursday evening in 2 weeks. Is that what we're looking at?
Probably, if we-
Okay, I mean,
as long as we
whatever
can,
y'all's-
as long as we can get the room, I think.
Okay, because we obviously would like to try to move forward as well.
Well, that's what I was trying for a week. but
Absolutely.
The
No,
town attorney said too, so.
I appreciate that.
And I'm sorry we
Attorneys
couldn't
give
do
away
it tonight,
sometimes,
but we need to make sure we have a clear sign at the property and.
I agree.
And a clear notification on the agenda next time.
Absolutely. Okay. Thank you for your time.
Thank you, Steve.
Yes, ma'am.
Harry, you want to talk?
I'm Harry Cash. I just want to address one thing that I think needs to be clear before we actually have a hearing. You're all, the Board of Zoning Appeals, administrative review jurisdiction is to hear and decide appeals where it is alleged by the appellant that there is an error in any order, requirement, permit, decision, or refusal by the building inspector or any other administrative official in the carrying out or enforcement of any provision of these regulations. So we need to be clear what decision has been made that has been appealed.
Well, I believe the building inspector said that what she claims is an illegal structure, he said could be used as an office. So that's one of the items right there. Is this
Just needs
structure
to
legal?
be clear. There
Right.
are, I'm not picking on Ms. Kellum, but there are some things in her email that we know are not true. She says, I think, and I don't have it in front of me, but she says that she was told it was going to be occupied and that was going to be allowed. Well, what we now know is the kitchen's been removed, the bathroom's been removed, the water's been removed.
Did she write that prior to the removal of all the items?
She did, and at the time she sent her email, a decision had not been made.
Right.
That's my point, is what is she appealing?
Well,
A
there's
decision
still-
hadn't been made at that point.
Even if you want to say after all that stuff has been taken out that should never have been put in there, we have no building permit, not one permit or inspection was done on time.
I actually don't think we should conduct the hearing right now.
I
while the
agree. I just
complainant's
want
not
to
here.
point out, it needs to be clear what decision or order is being appealed.
Okay, I agree with that. We have another speaker. Would you like me to put
My name's Bill Sonnenberg. Like Mr. Jakeway and Mr. Cash, I'm an attorney. I haven't been practicing lately. We are the backyard 5 feet away from this outbuilding property owners. All I'd like to ask tonight is to be involved with the date that this gets heard and notice of the hearing. Would it be before this group?
Yes.
And we have a Hilton Head reservation. I'm not sure exactly which day it is, but you're aiming toward,
We're aiming for 2 weeks from today, if we can do that.
and if I have a big conflict with that, who should I get in touch with?
Either me or Chuck, because I don't schedule the building, but
Hopefully.
we'll
that
try
would-
to work
That would
with
be
you.
fine for me, so.
And the complainant wants to do it as soon as possible, obviously, so.
All right. And that may be perfectly fine with me too, that day that you pick, so.
Okay, and if you, for some reason you couldn't be here, if you can be happy with.
Submit something or-
Yeah. I think so. Or even, I know you FaceTimed last time, I think, or Zoomed.
I think I've been in front of the town and the planning commission and now this group, so.
I actually think this meeting is live, so you may be able to pick us up on the net.
But, yeah, we need his comments, so.
Aren't we videoing DCA meetings now?
All right, we'll
Okay,
try to stay in touch with you.
all right, thank you.
Thanks, sir. Any other comments or questions or?
I got a comment before we close our meeting. I think this board needs to have some personal time with Chuck, and is the mayor here?
Yeah.
I think we at least need that much. If anybody else wants to be here, I don't know. But I think we need to talk to those two at least.
All right. He's not here tonight. Oh, is he? Okay, yeah, he can be here as well. So everyone's welcome to depart if they'd like to. And we'll hear from you guys within a couple of weeks, I guess. I guess I'll go and adjourn the meeting and we can meet with the town staff afterwards.